Exactly, and that's an important consideration, because somebody will say, oh, my house is worth $800,000, what am I going to do? I can't get on MediCal. Well, it may be fair market value, but there are things that reduce that value for MediCal eligibility purposes.
Okay, so are there some related concerns during your lifetime for this? This is a question that came up.
Well, during your lifetime, you know, as long as
So
one of the spouses
is in the home.
As long as a spouse is in the home, or a disabled child is in the home of any age, or a minor child, and for California purposes and for MediCal purposes, which is different from other rules, a minor child is 21 years.
Oh, okay.
So as long as that's in place, then the home is exempt.
Yes.
If there is a single person, the home is still exempt and will not be touched during the person's lifetime. There will be a recovery claim after death, however.
Okay.
And that's something that you have to consider when you're doing MediCal planning.
Okay, and we'll talk about that in more detail, maybe a little bit later. What about concerns again after death? Then, so
well, there's the recovery claim, which is limited to the amount of MediCal benefits that were paid for you by the state of California.
Okay.
Or what's in your estate, whichever is less.
Okay.
So if you don't have anything in your estate when you die, then there's no recovery claim.
So next question is, do you have to exhaust your retirement benefits in order to qualify for MediCal?
No, because retirement benefits are, you know, in retirement benefits we're considering the 401k plan, the 403b plan, the IRA, the profit sharing plan, whatever is the deferred earning principle that's out there. Is you do not have to deplete it. If you are the person who earned the deferred earnings and you're in the nursing home, then you do have to draw on it.
Yes.
Some amount. If you're at home, you're the spouse at home, and you have a separate 401k or a separate IRA, no deduction, no withdrawals have to be made. It is exempt.
Yeah, other than for the required minimum distributions under the tax laws.
Exactly, so, and if you're not 71 and a half, you don't have to withdraw.
Right, don't have to, Okay. So what other assets then can you retain? So we talked about the retirement accounts and the home. And the home, you can retain a car, your heirlooms, your household furnishings, wedding ring. You can retain all group life insurance. You can retain your life insurance with a cash surrender value of, well, face life insurance. If you add it all up for everything you have, if it's under $1,500, it won't count. So there are not much life insurance under those. But then you start counting the cash surrender value. I see. And rather than the full value of the life insurance. There are certain annuities that if they are properly structured and do pay to the estate, to the state, MediCal first on death, then you can have some annuities, and that's a good vehicle for planning if you have a spouse at home, but not so good if you are a single person. So, and those are, you can have a funeral plan, you can have a burial account of $1,500 for yourself and everybody in your nuclear family. Okay. And that can add up to quite a bit. Business property, income producing property is exempt, so if you're part of a partnership, that doesn't count. If it's impossible to sell the asset, that is exempt. If there are co-owners and the co-owner refused to sell the property, that's exempt. So there's
a lot of exemptions out there that are pretty not well known.
Yes.
And in planning and looking at a person's estate for MediCal, what you want to look at is what's unique about this? What can you do to take assets that might be countable and convert them to non-countable assets?
Now, when do you
do this?
When do you do this stuff? Yeah.
Well, for my practice, I don't like to do it before a person really becomes eligible. But what's important is that your estate planning documents allow you to do the kinds of things you need to do. And in particular, your estate planning documents should have some sort of grant that the trustee can make gifts of your property, or provisions. Powers of attorney would also have gifting powers. One of the very critical things that I've seen is where the power of attorney says that I have gifting powers and I can make these gifts, but all the assets are held in the trust.
Yes.
And the attorney, in fact, can't get to the assets in the trust.
Unless he happens to be the trustee.
And, well, they have to have express authority to gift property out of the trust. So there are certain things that your estate planning package should include so that when it comes time, if it ever comes time, you can use those powers that you've included to do the planning. I've found that depending on the complexity, it's some of my clients can be qualified within a month or almost immediately. Others, like today, I had somebody whose estate had about $400,000 of non-exempt assets, and we started talking. Is it worth it to go through the planning for MediCal assets when really you're dipping into principal at about $25,000 a year? You have to balance all those things and choosing.
And it means you're giving up, in some cases, control of assets and so forth in order to get them in that condition.
Absolutely. You're giving up control, and you're one of the things when an elder goes into a nursing home is there's a loss of autonomy.
Right.
And to compound that with also losing your identity of your possessions can be quite devastating. So you really do want to balance that.
Yeah. It's hard, especially when they first get into, like if they have dementia and they first get in, then afterward, it gets to be a point, I think, where, well, they have trouble remembering where they put the darn stuff anyway, so.
Well, you know, one of the things, I was just talking with my client today, that one of the things, you know, putting somebody into a long-term care facility is a very difficult decision.
Extremely.
You're giving up control, you're giving up care of the elder or the person to other people. And I was telling my client today that one of the most critical factors in receiving quality of care is the frequency and the irregularity of visits to the resident. So if you come in the morning one day and an afternoon and an evening,
it creates confusion.
Well, it doesn't set up a regular pattern.
Yes.
And since very often the person in the facility can't be their own advocate, the frequency and the contact allows somebody to be a strong advocate for them.
Yes. We need to move along here. What can you do to qualify for MediCal if your assets exceed the limits that we were talking about earlier?
Well, there are many things you can do. Currently in California, gifting is not, does not disqualify you. It may delay eligibility, but it doesn't disqualify you. So that is one mechanism.